Hello, I am Anna Benedetti from the International Humanitarian and Criminal Law Platform at the Asser Institute, and I'm very glad to be here today with Tomas Hamilton, who during this brief interview for the International Crimes Database will discuss the role of international criminal law in regulating the arms trade. Tomas is a PhD candidate at King's College London and a former visiting researcher here at the Asser Institute. And he's also worked for the International Criminal Court, for the Extraordinary Chambers in the Courts of Cambodia, for the BBC and Oxford University. And the subject of his PhD research is accomplished liability of the arms trade under international criminal law. And he's also in the process of writing an ICD brief on this topic, which will soon be available on the ICD website. So thank you very much, Tomas, for being here today. And maybe you could start introducing the topic, telling us how is arms trade linked to the commission of international crimes around the world, and why should individuals be considered responsible legally or morally for their role in the arms trade?
Okay, thanks Anna. Well, I think the first thing to say about the PhD research that I've been doing at King's College London is that it's focused on a very limited aspect of the arms trade, and that is where arms trading is linked to an international crime. So it's not to say that all arms trading should be vilified, or that there aren't legitimate security uses for arms trading, which may in fact reduce the possibility of international crimes. But the fact remains that if we think of recent atrocities, Rwanda, Yugoslavia, many of the conflicts in Africa, often arms trading is considered to be an important factor in fueling conflicts, in contributing to the scale of international crimes. And some people have made the case that it's often the leading factor. In terms of the moral responsibility of arms traders for this kind of trading, it's a difficult question, but I think in a lot of these situations, the prospect of international crimes being committed is abundantly clear to everyone involved in the trade. And so, to my mind, that does raise moral questions. The question then becomes whether that's reflected in law.
Yeah, and on the law, do you believe that international and domestic legislation on the arms trade provides for an adequate legal framework to the arms trade?
Well, I think what I'm starting to understand from my research is that the transnational regulation of the trade is wholly inadequate to prevent arms from flowing into situations where there's an international conflict. If we take the Security Council's system of arms embargoes, there are lots of examples of breaches that aren't enforced in any way. And we've seen this in the apartheid era in South Africa, 1994 as the genocide in Rwanda unfolded, and more recently in Libya and in Charles Taylor's role in Sierra Leone. So arms embargoes don't seem to have achieved what they set out to do. And if we look to domestic regulation, in theory, export controls should prevent some of these problems, but unfortunately, export controls in different states are very uneven and often not backed up by strong criminal sanctions. The Arms Trade Treaty, which came into force last year, looked like it might have ameliorated some of these problems, but in fact the wording of the treaty is very loose and grants states a lot of interpretive space to do what they like with the underlying principles of the treaty. And in fact there's some anecdotal evidence that as the treaty is being implemented, it's actually leading to relaxation of export controls on the basis that the treaty encourages that. So it may actually be a step backwards in some respect.
So you just highlighted important gaps in the existing laws on the arms trade. In such a context, is an international tribunal an appropriate forum for international prosecutions of arms trading?
Well, I think we have to take a realistic look at what international criminal tribunals have achieved in the past, and clearly an institution like the ICC is not going to offer a comprehensive solution for all of the gaps in arms trade regulation. But at the same time, I think it can offer a novel form of regulation, and it should be one kind of tool in the kit, as it were. I think international tribunals have the benefit of, at least in theory, a degree of political independence, which should mean that they can act in some situations where domestic authorities can't. At the ICC we have the complementarity principle, which means that this will only come into action where states are unwilling or unable, but still I think the ICC could play a role. In particular, something I've highlighted in the ICD brief that you referred to is the problem of third state brokering. And I think particularly in this situation, international tribunals could play a role.
Definitely. And very few international prosecutions have concentrated on the arms trade up until now. Do you have an explanation why did this happen? Do you have a possible explanation for this?
I think I could suggest three possible explanations. The first is that there may be a lack of legal basis, and perhaps we can discuss later some of the issues in the law. Secondly, there are political considerations. We saw this at the ICC when the first prosecutor announced the situation in the Democratic Republic of Congo and suggested that he was interested in investigating some of the commercial actors involved in that situation. And this led to a quite stiff reaction from a lot of stakeholders in the ICC. So I think that's always going to be a problem. And that's sort of linked to my third possible explanation, which is just that it's very practically difficult to go about doing these sort of prosecutions, and all of the practical limitations that courts like the ICC face in terms of obtaining suspects, protecting evidence and gaining state cooperation apply to arms trader cases, and perhaps they're even increased in arms trader cases where a state might not wish to see an arms trader prosecuted.
Of course, so many challenges.
Yeah.
Moving to modes of liability. Do modes of liability under international criminal law provide for a basis for international prosecutions of arms trading?
I think it's really difficult to answer at the moment because of the way international criminal law is still a young area of law and is still developing. Certainly, in my view, the modes of liability are still unsettled in some respects. At the ICC, we have to bear in mind that the court is free to depart from interpretations of the ICTY or the ICTR on the basis of the primacy of the Rome Statute as the core applicable legal source, combined with the fact that there's no formal stare decisis, no formal doctrine of precedent at the court, which would bind chambers to follow earlier decisions. So there's always going to be the possibility that a chamber interprets the law in a new way. The legal question that would be at the core of an arms trader case, in my view, is what level of knowledge is required to secure a conviction. Of course, many defendant arms traders would argue that their business is business, and there's no real intention or interest in what the arms are used for, and evidence to prove otherwise is going to be quite difficult to find, I think. But even if the standard chosen is knowledge, there's still going to be difficulties in proving that a defendant knew exactly what crime the arms were destined to be used for.
Absolutely.
So I think it's going to depend a lot on how the ICC develops these modes of liability.
But specifically in the context of the ICC statute, and in particular Article 25, what is the knowledge, like the level of knowledge that you think would be required for securing a conviction of an individual who transfers arms to the perpetrator of an international crime?
Well, I think if we look a bit more closely at the provisions of Article 25, it still remains quite unclear exactly what the implications are. I think everybody's agreed that Article 25(3)(c) requires some form of intention. So this is the provision which concerns assistance, including aiding and abetting. At the start of that provision, it requires an intention to further the purpose of the international crime. And the fact that this is included in the Rome Statute is no accident. And in fact, some of the states that advocated for the inclusion of this intention requirement did so specifically on the basis that they didn't want the ICC to have jurisdiction that might affect their arms trading. They made specific reference to that in the negotiations. In terms of 25(3)(d), perhaps this offers more of a realistic prospect of convicting an arms trader. The subsection 2 provides a much lower threshold, and I think perhaps the implications of that have not been fully recognised in the commentary on the Rome Statute and perhaps in the jurisprudence. That provision would create liability for an arms trader if they had knowledge of the intention of a group to act together and commit an international crime using the weapons that the arms trader supplied. So you can imagine a lot of situations where that might apply.
Where the intent is not required, but just the knowledge of the intention of the perpetrator.
Yeah.
Yeah, so lower standard.
Yeah.
Thank you. And as a final question, I want to touch upon an aspect which I find really interesting in your research, that is not only the role of international criminal law in the fight against impunity, but also a potential deterrent effect of international criminal law in the arms trade. Could you tell us something more about this?
Yeah, I think it's an interesting aspect of the literature on corporate liability in relation to international criminal law, that perhaps deterrence is more of a consideration for commercial actors than it is for other perpetrators of international crimes. And the authors who've suggested that this might be the case base their argument on the assumption that commercial actors act in a rational way. They carry out cost-benefit analysis to decide how to conduct their business, and therefore they'll be more perturbed to see the prospect of an international criminal conviction than other actors who might act more out of an opportunistic or forced way if they're the victim of circumstances, or perhaps who act according to an ideological motivation. Yeah. So I think that's an interesting suggestion that commercial actors might be more affected by this sort of prosecution, and perhaps that suggests a greater role for international tribunals. Absolutely. In this sort of case. But ultimately, I think we also have to remember that the arms trade is an incredibly lucrative business. Yeah. And whether the slim prospect of a conviction for an international tribunal will deter someone when the rewards are so great is definitely questionable.
Definitely. Thank you so much for sharing all your insights on this.
Thanks.
And we'll see whether the ICC will contribute to strengthening accountability for international crimes, including for those who participate through commercial activities. So thank you very much, Tomas, for being here with us, and thank you all for watching. And let me just remind you that Tomas's brief on the role of international criminal law in the arms trade will soon be available on the ICD website. Thank you.